Welcome to Court Adjourned. Check out this case with me and leave me some feedback. It could really get me out of a jam.
These are serious charges here. I mean, we think you'd take it serious.
They do, absolutely.
You don't.
The State of Ohio versus Robert Jefferson, case number 25CR1421. The defendant is present with counsel Michael Goldberg. A 6-count indictment was filed in this case on October 8, 2025. Counts 1, 2, and 3 are illegal use of a minor or impaired person in nudity-oriented material or performance, felonies of the second degree, in violation of Revised Code 2907.323A1 with forfeiture specifications. Counts 4, 5, and 6 are voyeurism, felonies of the fifth degree, in violation of Revised Code 2907.08C. The state has offered for the defendant to plead guilty to counts 3, 4, and 5 with the forfeiture specification to count 3. It is the state's understanding that today the defendant would like to withdraw his previously entered pleas of not guilty and plead guilty to these 3 counts.
Your Honor, I feel the plea deal is too lenient because most days I still have trouble showering and most nights I still have issues sleeping, along with nightmares even 6 months later. I feel due to the overwhelming amount of evidence it should go to trial and the defendant should be held responsible for all 3 counts on both charges. I feel there's absolutely no reason to drop any charges or lessen them because what the defendant did completely changed my life and cannot be undone.
Thank you. Mr. Jefferson, were you able to hear what the prosecutor said earlier here this morning, as well as what your attorney just said?
Yes, Your Honor.
They indicated to the court they believe it's your desire to withdraw your previously entered plea of not guilty and plead guilty to count 3, 4, and 5. And I'll go over those charges with you. Remaining counts will get dismissed. We would defer about May 23rd, 2025 in Wycliffe Lake County, Ohio, that you did photograph a minor who is not your child or ward. You did that, photographed them in a state of nudity, or you created, directed, produced, or transferred any material or performance that shows the minor in a state of nudity. That conduct constitutes the offense of illegal use of a minor in a nudity-oriented material or performance. It's a felony of the second degree. Do you understand what you're charged with and pleading guilty to in regards to count 3?
Yes, Your Honor.
Any questions about it?
No, Your Honor.
Charge also carries with it a forfeiture specification, which alleges during the commission of the offense that you had in your possession a black Samsung phone which was used as an instrumentality. An instrumentality is some type of property that's used to facilitate the commission of an offense. Here it's alleged you used this black Samsung phone to commit or facilitate the commission of the offense I just read to you. The purpose of the specification is that at the time of sentencing, any right, title, or interest you have in that property will be forfeited to the state of Ohio. Do you understand that?
Yes, Your Honor.
For the purpose of them disposing of it and getting rid of it. Any questions then about count 3 with the forfeiture specification?
No, Your Honor.
And count 4 is the next charge you're pleading guilty to. Counts 4 and 5 actually, they're same charge, just different dates. Count 4, it's alleged to have occurred on May 17th, 2025. Count 5, the conduct's alleged to have occurred on May 22nd, 2025. And in both of those counts, it's alleged that in Wycliffe Lake County, Ohio, that you did knowingly commit trespass or otherwise secretly or surreptitiously videotape, film, photograph, or otherwise record a minor with initials of GP in a place where a person has a reasonable expectation of privacy, and you did it for the purpose of viewing the private areas of the minor. That conduct constitutes the offense of voyeurism. It's a felony of the fifth degree. Do you understand what you're charged with and pleading guilty to in regards to counts 4 and 5?
Yes, Your Honor.
Any questions about it?
No, Your Honor.
Now, there are 3 other charges in the indictment that are being dismissed pursuant to the agreement. Is that your understanding?
Yes, Your Honor.
Any questions about any of those 3 charges?
No, Your Honor.
If you made it this far, hit that like button and subscribe. I could really use your help right now.
3. This offense is what we call a qualifying offense, and it's simply called a qualifying offense because it was committed after March 22nd of 2019. After that date, all felonies of the first or second degree are subject to indefinite sentencing. Indefinite sentencing means that a minimum sentence and a maximum sentence will be imposed if a prison sentence is imposed. In this particular matter, if a prison sentence was imposed, I would select a number in the range of 2 to 8, 2, 3, 4, 5, 6, 7, 8. And that number, whichever number I selected, would be the minimum sentence you would have to serve. You understand that?
Yes, Your Honor.
Now, in order to determine the maximum sentence, it's simply a mathematical formula. You take half of whatever the minimum sentence is I select, you add that half to the minimum sentence, and that becomes the maximum. So I'm going to give you a few examples just to make sure we understand. If I selected 2 years as the minimum sentence, half of that is 1. You'd add the 1 to the 2, your maximum is 3. So it would be an indefinite sentence of 2 to a maximum of 3 years. If I selected 6 as the minimum, half of that is 3. You'd add that to the 6, the maximum would be 9. So it would be an indefinite sentence of minimum of 6, maximum of 9. And likewise, if I selected 8, which would be the maximum for the minimum sentence, half of that is 4. You'd add that to the 8, your maximum would be 12. So it would be the maximum sentence you face on count 3 is an indefinite prison term of a minimum of 8 years, maximum of 12 years. Do you understand that?
Yes, Your Honor.
Any questions about that?
No, Your Honor.
Now, the other remaining counts, I think they're 4 and 5, is that correct?
Yes, Your Honor.
4 and 5 are felonies of the 5th degree. Those are each punishable by a possible term in prison of a minimum of 6 months, a maximum of 12 months, or any whole number in that range. So if I imposed a prison sentence, I'd select one of those numbers, 6 through 12, and that'd be the number of months you'd have to serve for that particular count. Do you understand that?
Yes, Your Honor.
Now, since there are 3 separate offenses here, if I impose a prison sentence, I would impose it on each count in the manner that I just described. And then as the judge, I have the discretion to run those prison terms either concurrent or consecutive to each other. Concurrent means together. You'd serve them at the same time. Consecutive means one after the other. So you'd serve, if all 3 were consecutive, you'd serve the prison terms on the felonies of the 5th degree first, whatever those were. Then you'd serve, after you completed that, the indefinite sentence on count 3. You understand that?
Yes, Your Honor.
So in this particular case, if I impose the maximum sentence on each count, the 8 to 12 plus 12 plus 12, 8 to 12 years plus 12 months plus 12 months, the maximum sentence you face in this case is an indefinite prison term of a minimum of 10 years, maximum of 14 years in prison. You understand that?
Yes, Your Honor.
Facts would show that during the time frame in the indictment, the defendant was living with his ex-girlfriend Angela Priola and Miss Priola's 16-year-old daughter, minor victim GP. They resided at a house in Wickliffe, Lake County, Ohio. On May 17th, 2025, May 22nd, 2025, and May 23rd, 2025, the defendant set up his Samsung phone in the bathroom of the home where minor victim GP had a reasonable expectation of privacy to secretly record her. On each date, the defendant recorded video of minor victim GP going to the bathroom and or showering while she was in a state of nudity to view her private areas.
Mr. Jefferson, were you able to hear what the prosecutor had to say regarding what she believes the evidence would show if we had a trial?
Yes, Your Honor.
What, if anything, do you have to say about those facts as they were just presented? Are they true? Did you do what she said?
They are true, Your Honor.
Very well, then, regarding count 3, charging with illegal use of a minor in a nudity-oriented material or performance, a felony of the 2nd degree, what is your plea to that count?
Guilty.
What about the forfeiture specification regarding the use of the phone as an instrumentality? What is your plea to that?
Guilty.
As to counts 4 and 5, each charging with voyeurism, each felonies of the 5th degree, occurring on different days, what is your plea to each of those 2 counts?
Guilty.
Oh, these are serious charges here. I mean, we think you'd take it serious.
I do, absolutely.
You know.